Mr. President, 2 weeks ago, President Trump nominated 10th Circuit Judge Neil Gorsuch of Colorado to fill the vacancy left by the death of Supreme Court Justice Antonin Scalia. Judge Gorsuch, in my opinion, is the ideal choice to fill this seat. He has impeccable credentials and a decade-long record on the bench of demonstrating a keen understanding of the proper role of a judge. Given the increasingly contentious nature of the confirmation process, it is no surprise that many of my colleagues on the other side of the aisle and their special interest group allies are stretching to find anything objectionable about Judge Gorsuch, no matter how ridiculous. Today, I wish to address one of their latest, most outlandish claims, that Judge Gorsuch would not serve as an independent check on the executive branch. For example, last week in Politico, Senator Schumer, the distinguished senator from New York, declared in an opinion piece, quote, "The most important factor in assessing a Supreme Court nominee is whether or not the potential justice will be an independent check on an executive who may act outside our nation's laws and the Constitution," unquote. Now, Senator Schumer doubled down on these comments in the New York Times. There he argued that it was impossible for him to discern Judge Gorsuch's judicial independence when they met in person. Why? Because Judge Gorsuch refused to say how he would rule on specific issues or how he would review particular government actions. These misleading narratives are an irrelevant, wasteful distraction from our consideration of Judge Gorsuch's sterling record and the merits of confirming him to the Supreme Court. Last month, I warned that the left would use these diversion tactics in an attempt to discredit the president's nominee. Shortly before Judge Gorsuch's nomination was announced, I predicted in an opinion piece in the Washington Post that advocates and interest groups would want to know how the nominee would decide particular cases before those cases ever reach the court to make sure the nominee is on the right team. I was right. Our nation's founders would have been embarrassed by such questions. Instead, the questions we ask should focus on whether the nominee will interpret and apply the law faithfully and neutrally, no matter what the issue is. After all, that is what our Constitution demands. Our founders are not the only ones who would be embarrassed. I've been in the Senate for the last dozen Supreme Court confirmations. Every nominee we have considered has rightly refused to answer such questions. Consider, for example, Justice Ginsburg's response at her confirmation hearing. She said, let me just refer to it right here on this chart. A judge, quote, "A judge sworn to decide impartially can offer no forecasts, no hints for what would show, not only disregard for the specifics of the particular case, it would display disdain for the entire judicial process," unquote. Just last month in a speech in Arizona, Justice Sotomayor had an even stronger warning against asking and answering such questions. She said, "What you want is for us to tell you how, as a judicial nominee, we're going to rule on an important issue you find vexing. Any self-respecting judge who comes in with an agenda that would permit that judge to tell you how they will vote is the kind of person you don't want as a judge," unquote. So let's stop with this nonsense of trying to get Judge Gorsuch to prejudge issues that could come before the court. I hope my colleagues appreciate the irony in asking a judge to say how they would rule on particular issues in order to prove that the judge is judicially independent. I agree with Justice Sotomayor. A nominee who will tell you how she would vote is the kind of person you do not want as a judge. But if judicial independence really is the most important factor, as Senator Schumer suggests, then this confirmation process should be the easiest one in the Senate history. Over 11 years on the 10th Circuit, Judge Gorsuch has consistently demonstrated in his judicial opinions and other writings that he deeply values the constitutional separation of powers between the three branches of the federal government. Judge Gorsuch understands that the Constitution gives each branch distinct roles. Congress makes the laws. The president enforces those laws, and the courts interpret those laws and the Constitution. The branches may act only according to the powers the Constitution grants them, with the remaining powers and rights reserved to the states and ultimately to the people. With respect to the power of the executive branch, Judge Gorsuch has a strong record of reining in actions which violate the Constitution and the law. Perhaps the best example is his opinion in the immigration case, Gutierrez Brizuela W. Lynch, versus Lynch. There, the Attorney General attempted to apply a new agency rule retroactively prohibiting a non-citizen from receiving relief under federal immigration law. Writing for the 10th Circuit, Judge Gorsuch ruled that such action exceeded the executive's power to enforce the law. In a separate opinion, he noted that there is an elephant in the room, the so-called Chevron deference doctrine, which requires courts to defer to federal agency interpretations of the law we pass. And he expressed constitutional concerns about Chevron deference. Judge Gorsuch wrote, and we'll just refer to this chart again, quote, "The fact is, Chevron permits executive bureaucracies to swallow huge amounts of core judicial and legislative power and concentrate federal power in a way that seems more than a little difficult to square with the Constitution of the framers' design. Maybe the time has come to face the behemoth," unquote. Judge Gorsuch then proceeded to provide a textbook explanation of the proper separation of powers under our Constitution. As he stated, the founders included a strong separation of powers in the Constitution because, quote, "a government of diffuse powers," they knew, "is a government less capable of invading the liberties of the people," unquote. Now, as my colleagues know, I am no fan of Chevron deference. Last Congress, I introduced the Separation of Powers Restoration Act to get rid of it. As I noted when I introduced the legislation, regulators have taken advantage of the court's deference under Chevron to shoehorn the law for their own political agenda and expanding their authority well beyond congressional intent. But the Constitution's separation of powers makes clear that it is the responsibility of the courts, not the bureaucracy, to interpret the law. So I am pleased Judge Gorsuch understands that the Constitution requires federal judges to serve as an independent check on how federal agencies interpret the laws we enact. Separation of powers is not just about ensuring that the executive branch performs its proper role of executing the law. Separation of powers is also about making sure federal judges understand their proper role under the Constitution. As Chief Justice Marshall famously explained in Marbury versus Madison, judges have a constitutional duty to say what the law is. Simply put, judges must be faithful interpreters of our laws and the Constitution. Under our constitutional separation of powers, it is not the role of federal judges to make or change laws by imposing their own policy preferences. It is not their role to look beyond the law to consider their personal views and feelings. And it is not their role to choose winners and losers based on subjective beliefs that favor one group over another. In my 40 years in the Senate, I have reviewed the record of hundreds of nominees to the federal bench. I don't think I have ever reviewed the record of a nominee who better understands his proper role under the Constitution than Judge Gorsuch. Consider, for example, Judge Gorsuch's touching tribute to Justice Scalia that was published last year in the Case Western Reserve Law Review. In that speech, Judge Gorsuch eloquently explained how judges should not be in the business of ruling in ways that reflect their own political views or policy preferences. Judges, after all, are not elected legislators. Instead, judges should interpret the law as written. They must start with the text of the statute and then utilize the traditional tools of statutory interpretation to discern the meaning of any particular law. Judge Gorsuch understands, to borrow from Alexander Hamilton, that the judiciary should be the least dangerous branch. These aren't just words. Justice Gorsuch's judicial record confirms that he lives this judicial philosophy of restraint and humility. In an essay I published last week on the SCOTUS blog, I reviewed a number of judicial opinions by Judge Gorsuch that demonstrate his commitment to the separation of powers and the proper role of a judge in our federal system. I will not go through all of those cases here, but I ask that the essay be submitted into the record at this point.
Without objection.
To be sure, that Justice Gorsuch would be a fierce defender of the separation of powers does not mean that his rulings will match his policy preferences. As Justice Scalia wisely remarked, good and faithful judges will not always like the conclusions they reach in interpreting the law. And it certainly does not mean that his rulings will match my policy preferences or those of my colleagues. As I have repeatedly stated on this floor over decades, that is not the proper inquiry when we assess the qualifications of a nominee to the federal bench. Federal judges must be judges, not super legislators. The bottom line is even a casual review of Judge Gorsuch's opinions should eliminate any concerns my colleagues may have concerning Judge Gorsuch's commitment to the Constitution's separation of powers. Just any review of it would lead you to that conclusion. In his opinions, Judge Gorsuch has resisted executive branch efforts to make laws as opposed to merely enforcing those laws. Judge Gorsuch's opinions and other writings make the compelling case for separation of powers in a way that finds few rivals on the current federal bench. If my colleagues are truly concerned about the proper separation of powers between the three branches of government, there is a simple solution. Confirm Judge Gorsuch as an Associate Justice on the United States Supreme Court. Now, Mr. President, I will now change the subject and ask that my further remarks be placed in an appropriate record.